there is no loss. The $1,000, he paid $1,000 for that truck is what he did. Bottom line. And then he got the extra money. He could put that toward repairs. He could have put that toward anything he wanted. So for those reasons, and based upon what's before the court, I am not going to order restitution of it. He made a decision. Now, why would somebody make that decision? I understand why he made the decision, and again, why I appreciate his testimony. He made that decision because had he taken the $3,000, he would have gotten the $3,000. They would have taken the truck, and he would have actually never seen the $3,000. Why would he have never seen the $3,000? Plead no contest to the charge. Failure to report an accident under 662, 90-day offense. Upon a successful no contest plea, count 1 would be dismissed.
That's correct, Your Honor. That's correct, Your Honor.
All right, very good. Need you up at the podium, young man. Raise your right hand. Be sure.
Solemnly sworn to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
George Walker.
Sir, it is this court's understanding that you're going to plead no contest to the charge of failure to report an accident. That is a misdemeanor, punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes.
You understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is that you need to understand that it means that you're not further desirous or wanting to contest this charge. You understand that? Yes?
Yes.
Okay.
Sorry.
The other thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for the no contest plea, Mr. Elm.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You had previously signed an advice of rights form. Is that correct?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 25-11648. Any objections to the court having reviewed that report?
None from the people? No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of sentencing and the time of my acceptance of your plea, if you commit misconduct as defined under the Michigan court rules, the court would not be bound by any sentence recommendation or evaluation. Do you understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people? No, Your Honor.
Have I complied with the court?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. I don't know that there'll be a necessity to send the defendant over. I would proceed to sentencing immediately but I understand there's an issue regarding restitution.
Yes, Your Honor. We do have the victim here. We were prepared to do.
All right. In this case, to send to the court, I'll order fines and costs in the amount of $350. I will also spend 90 days in jail with reference to the restitution. And it sometimes can get complicated with automobile crashes. Certain limitation when somebody doesn't have insurance as to what they can collect, or if they had PLPD, what they can collect. In this case, it even gets more complicated in a sense, because, and I'm going to give a couple scenarios in terms of assessing the damage. First of all, individual will be entitled to the restitution for their loss. They are to be made whole. That doesn't mean that they can get a new vehicle. And so those would be sort of the extremes in terms of looking at it. In this case, what the victim chose to do is causes maybe for them a certain problem with the restitution. The only value I know for this vehicle is what Progressive valued the vehicle. That is $2,932.19 is what they valued that vehicle. Now, it may have had a greater value, and I'll explain that, but that's the only value that's before that I have. He could have chosen, and the insurance company gave him an option. He could have taken the 2932.19. The insurance company would have taken as scrap, in essence, the truck, and then theoretically everybody's done, in theory. But had he done that and then shown that the vehicle was actually worth more, but the insurance company wasn't going to pay him more, he might have been entitled to restitution for what that actual value was. But I don't have that before me. What he elected to do instead was, and he was very honest and I appreciated his testimony, what he elected to do instead was, I won't take the payout. I will, in essence, keep my vehicle, pay my deductible, and get the back balance or get the excess amount. So if you follow the math here and the calculation here, what really ends up happening is he's paying $1,000 for that truck is really what's happening. And so he's whole in that regard in a lot of ways, because if he had done it the other way, what would have happened is he would have taken the 2,900, I'll just call 3,000. He would have taken the 3,000. They would have taken the truck. He would have said the truck is worth more, and then he would have come after him for what that amount was. That's how he would have been made whole. But he's been made whole because he has the vehicle. But that doesn't mean he again gets to take that vehicle back to what he says the condition was. Because in theory, that's not part of his loss, I don't think. And so he made a decision. Now, why would somebody make that decision? I understand why he made the decision, and again, why I appreciate his testimony. He made that decision because had he taken the 3,000, he would have gotten the 3,000, they would have taken the truck, and he would have actually never seen the 3,000. Why would he have never seen the 3,000? Because there's a lien holder. They would have paid it over to the lien holder, and he'd still have to pay on this truck that he no longer has. I get why he made the decision that he made, but that doesn't mean that he has a loss that this defendant is responsible for. He made his financial decision, and he has his truck, which he says has that value of going up to 500,000 miles. Again, most people know I'm a Ford guy. That's a Chevy. Yeah, I don't know. But anyway, I say that facetiously. But I'm just saying there is no loss. The $1,000, he paid $1,000 for that truck is what he did. Bottom line. And then he got the extra money. He could put that toward repairs. He could have put that toward anything he wanted. So for those reasons, and based upon what's before the court, I am not going to order restitution of it. When can you pay the fines and costs of $350?
Your Honor, can we have a couple of weeks, please?
Pay it by April 15th.
Gotcha.
Thank you.
Thank you very much, Your Honor.
Thank you.
Appreciate you.
Are we ready? Are we ready to roll? We're good to go. Prosecutors in. You're fine. Let's do this. Court does call the case of the People versus Michael John Clark II. Do I have a DV?
Yes, I just put it in here.
Just half a step forward. Right there.
Woods?
Tiffany Woods for the people.
All right, there she is. All right.
Good morning, Your Honor. Joe Simon on behalf of Mr. Clark. State your name, Michael.
Your Honor, my name is Michael John Clark II.
All right. He's here for purposes of arraignment on a stalking case.
Waive formal reading, Your Honor. Stand mute.
And in every way, formal reading, standing mute, the court will enter a not guilty plea on his behalf. This is mine. I will set a retrial in this case for April 6th, 2026, 9 a.m. As to
I don't know if the people want to go first.
people have a request on bond.
Judge, I'm just pulling up the case. I need one moment.
All right. I don't. Form on it.
Your Honor, before she speaks as to bond, this is a case that's going to be before Your Honor. Is it possible to schedule that at 10 o'clock instead of 9? I have to be in Chelsea at the same time. That would work out perfectly.
You things benefit him. Yes, I'll set it at 1 p.m.
Well, I should be quiet. Ms. Woods?
Yes, Judge, are you ready?
Oh yeah, I'm ready.
So, Judge, we'd asked for no contact with Peyton Lee Trelfa, and we're also asking for a GPS tether hot zone. The address would be 244 Oaklawn Avenue in Ypsilanti. So I guess what happened here, Judge, was the defendant and victim in this matter work with one another and previously dated. The victim ended the relationship and the defendant repeatedly followed her at work. On one occasion when she was leaving work and walking to her car, the defendant chased her in the parking lot on foot while she was attempting to go to her car. On another occasion, she was attempting to talk with the victim. Then the victim told defendant that she did not wish to talk with him. And then she also texted her supervisor telling him that the defendant would not leave her alone. And then at some other points, he would stand outside of her vehicle. He would continue to follow her. He not only with the text messages, he was sending her gifts at her home address. He also left her a beverage at her locker and work. So we're asking for no contact with the victim based on those allegations. Judge, we would also ask for all standard bond conditions, including no assaultive behavior, no stalking behavior, no firearms, ammo, components, or weapons. Do not possess or use any devices for creating gun components. No alcohol, drugs, marijuana, and not to leave the state.
What was the address you gave me that you did wanted to no go?
244 Oaklawn Avenue in Ypsilanti.
Said Oaklawn.
That's correct, Judge. I will spell it to you. It's OAKLAWN.
And there would not be a need for the 1200 State Circle? Or is there a need for a no-go to that address also?
Let me see, is that the work address? Let me look real quick.
It's the stated address in the complaint.
Your Honor, I do have information on that one. It's my turn.
Will it clarify?
It
I
should.
believe the 244 Oaklawn Avenue is the address where the victim lives.
Yes. The 1200, Mr. Simon, do you know what that is?
I do. That is in fact the work address. It's Huron Valley Ambulance. My
Grand Valley Ambulance?
yes. And, you want me to continue? I'll wait till it's.
Are they both still working there?
That's what I wanted to clarify. They are, Your Honor, but they are and they aren't. So I know you're going to roll your eyes at that statement, but my client, this matter was investigated internally there. My client is technically on administrative leave. The investigation there is concluded. The only reason he's not fully reinstated at work is because of this pending matter, and they want to see how it resolves. But here's how HVA handled the matter. My client is has to be there present 1 day a week. To his continuing education is there, but he arrives at a time that is a completely different shift, separated by like 3 hours from the shift of Ms. I don't know how to say her last name, Tralfa. She is on a night shift, gets off at 5 a.m. On Wednesdays when he goes to his continuing education at 8 a.m. That would be the only time he is on that campus is on Wednesdays at 8 a.m. And he does want to be able to continue because otherwise he will lose his employment. And so he has no problem at all with a no contact. He not only will not go to the address in Ypsilanti, but he lives in Hillsdale. They have quite a geographic distance between them.
I guess with that explanation, what happens if her shift changes?
Then he's going to have to not be around to comply with his bond conditions.
But right, I get that. But does HVA then switch his shift or what?
Well, just tell me.
We have a shift that change every 6 months until for another 3 months, but we have our next one. And they've already set up my work shift being on different days.
Right. Your Honor, he's saying that the rotations in schedule don't happen for a number of months, and the first review is 3 months out.
Yes.
So the earliest there could be a change would be that.
3 months from now. All right. Okay. Anything else you want to say, Mr.?
Yes, Your Honor, I do request a personal bond. My client's a lifelong resident of the state of Michigan. He owns a home in Hillsdale. I've explained the employment situation. I did tell him there was a possibility of a GPS tether just because of the nature of the charges. I can tell Your Honor that I don't have the complaint in front of me. I don't know if it lists a date range, but I can confirm from what I understand that there is a cessation of all contact a date in February, that there hasn't been any contact, there won't be any future contact. My client will abide by any court order to refrain from contact with the complainant, and if the court imposes a tether, he's prepared to walk right over to community corrections today. I alerted him that that was always a possibility, and he's not a drug user or alcohol user, so he'll abide by those conditions as well.
Court will set the defendant's bond at $25,000 personal cognizance. I will order all standard, including no assault behavior, which I'll go through specifically. No possession of any weapons, firearms, ammunition. There is also to be no possession of any alcohol, recreational marijuana, or any illegal drug. Do you understand that, sir?
Yes, Your Honor.
Hesitated. You understand what I
I
just?
think he wanted.
I was reading what was being written down. I
Okay.
apologize, Your Honor.
You are not to leave the state of Michigan without permission of the court. You're not just indicated to possess a firearm, ammunition, or anything fashioned to be a weapon. You're not to assault, terrorize, frighten, intimidate, stalk, molest, harass, or stalk anyone. You are to have no contact with Peyton Lee, is it Trelfa? Except with a civil standby with the police. And when I say that, you are also not to have or attempt to have any direct or indirect contact with the above named individual in person or through others. You are not to have contact by electronic communication, but this is including but not limited to phone, email, texting, internet, social media. You are not to refer to that individual in any social media, I should say, or online in any. You understand that, sir?
Yes, Your Honor.
You are not to go to the 244 Oakland Avenue in Ypsilanti. I'm also going to indicate that you are not to go to the 1200 State Circle if Miss Trelsa is present. That way, I think, could cover it if this extends beyond that. So if she's there, you can't be there. Understood?
Yes, Your Honor.
That's not your home address, but if it were your home address, you would need to find another residence. You are not to violate any criminal law. You're to personally appear at all court proceedings and other places as directed by the court. I will place the defendant, if I hadn't said so, on a GPS tether with the exclusion zone as requested of the Oakland Avenue in Ypsilanti. Anything further from others?
What did you want to come?
Nothing from the people.
No?
Transfers.
Like, when you want to go out of state, you'll ask and we'll get position.
Okay. It's just as it happens randomly. So that was my only concern. I can tell them no, I guess.
Are you traveling between now and your next pre-trial?
No, sir.
Okay, and we'll address that then. My client was just saying that every now and then his job would require him to go out of state for transferring a patient or something. And I asked him if he had anything before the pretrial. He doesn't believe he does. And I know the court doesn't like to give blanket permission on that, but.
Right. And I think if you talk to the prosecutor, maybe or work something out that would allow its travel.
Thank you, Your Honor.
All right. Thank you.
Wait for me in the conference room.
Court does call the case. People versus Dominique Bailey. They're not here. Yeah. They dropped. All right, I'll wait on that. Quite a while ago.
Before you took this.
I don't know why they're not here. They were scheduled, they've left. I will issue a bench warrant for failure to appear. Bond will be set in the amount of $1,000, 10%. That warrant will issue immediately. Court calls the case People versus Maggie Cochran.
Not sure.
They're not here. Are these are set for arraignment?
These are set for arraignment in.
Got it. So they did receive notice. He doesn't get order to show causes, does he?
No, he does not.
Bench warrant will issue for defendant failure to appear, bond 1,000, 10% privilege. That warrant will issue immediately. Court calls the case People versus Brian Culver. Over. Mr. Culver, state your name.
Brian Culver.
All right. So you are here for the purposes of arraignment. The complaint in this case alleges that on or about November 24th, 2024, at the location of 7,000 East Michigan Avenue, that being the Walmart in Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of retail fraud in third degree. Do you understand what you're charged with, sir?
Yes.
That is a misdemeanor, punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
Yes.
Public defender, please.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Culver. At this time, Your Honor, we will waive the formal reading of the charges, be standing mute, and I'll be requesting a personal reconnaissance bond on my client's behalf based upon his appearance here today in court.
Anything from the people?
Yes, Judge. In this case, we just asked for a no-go to. The address would be 7000 East Michigan Avenue in Saline. It's the Walmart.
Okay.
We'd also ask for all standard bond conditions, including no assaultive or stalking behavior, no firearms, ammo, or components, not to leave the state, do not possess or use alcohol, marijuana, drugs, do not violate any criminal law, things of those nature. Thank you, Judge.
Set the defendant's bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior, possession of any weapons, ammunition, firearms, or anything fashioned to be a weapon. You are not to possess at this time, possess or consume any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
I'm also going to indicate that you're not to go to any Walmart in the state of Michigan. You understand that, sir?
Yes.
I'll set pretrial in this matter for April 15th, 2026, 9 a.m. or as your invite indicates. Thank you. Did he need to go to a breakout room to get information?
I believe so.
Yes, Your Honor.
Who are we putting him in with?
Maybe, Ms. Vicky, yes.
Who? Okay, fine. Put him in there.
Thank you, Your Honor. I appreciate it.
Yes, sir. Court does call the case. People versus Joe Faulkner. Check in. Joe Faulkner. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege on that. That will issue immediately. Court calls the case. People versus Darrell.
So I'm here, Your Honor.
What's your name?
Joe Faulkner.
You got it. Mr. Faulkner, you are here before the court on a misdemeanor complaint that alleges that on or about January 12, 2026, location of Clover Lane Drive in Pittsfield Township, Washington County, State of Michigan, you did operate a motor vehicle while your driver's license was suspended, denied, and or revoked. Do you understand that charge, sir?
Yes.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Court should also advise you that your vehicle could be subject to mobilization. Do you understand all of that, sir?
Yes.
First question I have for you is, do you wish to be represented by an attorney?
Yes.
Public defender, yes.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Mr. Faulkner. At this time, Your Honor, will be standing mute as to the charges, and I'm requesting a personal reconnaissance bond based upon my client's appearance here today in court and the nature of the charges being a traffic offense. Thank you.
Defendant name away from reading, standing mute. Court will enter a not guilty plea. Do the people have any statement regarding bond?
No, Judge.
Bond is set in the amount of $5,000 personal recognizance bond, standard conditions, no assaultive behavior, possession of any weapons, ammunition, or anything fashioned to be a weapon, no alcohol, recreational marijuana, or any illegal drugs. I'll set pretrial in this matter for April 15th, 2026, 9 a.m. Thank you. Did he need to go into a breakout room also?
Yes.
All right. Mr. Runner, you'll need to wait. We're going to put you into a virtual breakout room so that the public defender can get your information, sir.
Okay.
Thank you. Court does call the case. People versus Darrell Kubiak. Or Kubak, I think it is. I'm putting syllables in. Sir, your name?
My name is Daryl Kabaki.
Tabaki. I messed that up entirely. Okay. My apologies. All right. Not saying I won't do it again, but my apologies this time. All right. Sir, you are before the court on a misdemeanor citation that alleges that on or about March 6, 2026, at the location of westbound I-94 in Pittsfield Township, Washington County, State of Michigan, that you operated a motor vehicle while your driver's license was suspended, denied, and or revoked. Do you understand that charge, sir?
Yes, Your Honor.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization. You understand that, sir?
Yes, Your Honor.
First question I have for you is, do you wish to be represented by an attorney?
Yes, sir.
Public defender case.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Mr. Kabaki. At this time, Your Honor, as it relates to your charges, we will be standing mute, and I'm requesting a personal reconnaissance bond based upon my client's appearance here today in court and the nature of the charges being a traffic offense.
Any comment from the people?
No, Judge, we just asked for the standard bond condition.
Defendant every way formal reading, standing mute, court will enter a not guilty plea. I'll set pretrial in this matter for April 15, 2026, 9 a.m. I'll set the defendant's bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assault behavior, possession of any weapons or ammunition, or anything fashioned to be a weapon, no alcohol, recreational marijuana, or illegal drugs. You understand all of that, sir?
Yes, Your Honor.
All righty. Thank you. We will put you into a breakout room so they can get your information. Okay?
Thank you.
Thank you, sir. Court calls case People versus Melvin Napier. Melvin Napier. No response. Bench warrant will issue for defendant's failure to appear. Bond $5,000. Give a 10% privilege. Warrant will issue immediately. Court calls the case of the People versus Pauline. Is it Schoener? Oh, there she is. Hello, ma'am.
Thank you.
You got it. Okay, you're okay. You can have a seat, ma'am. Hey, you don't have to stand for me.
Thank
Your
you.
name?
Pauline Shaner.
Shaner. Okay. Ma'am, you are before the court on a misdemeanor complaint that alleges that on or about January 6, 2026, at the location of 771 Airport Boulevard, that being the Costco in Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of retail fraud in the second degree. Do you understand the nature of that charge, ma'am?
Yes, I do, sir. Your Honor.
That is because the value, I think in this case, no, because of a previous conviction.
10 years ago.
Yeah, in this court in 2016. This makes this a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value taken. If that's greater than $2,000, that would become the maximum fine. You understand that, ma'am?
Yes, Your Honor.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, sir. Yes, Your Honor.
This is a public defender case.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Ms. Schroner. At this time, Your Honor, as it relates to the charges, we'll be standing mute, and I'm requesting a personal reconnaissance bond based upon my client's appearance here today in court.
And then having waived formal reading, standing mute, court will enter a not guilty plea. I will set pretrial in this matter for April 15th, 2026, 9 a.m. as your invite indicates. If people have anything they want to say regarding bond?
Yes, Judge, we'd ask for a no go to the Costco at 771 Airport Boulevard. And
There's to be
So if there's anything you can't hear me say or don't understand, just let me know and I'll speak up and try to clarify myself, okay?
Okay.
So you testified that when you reached out to your insurance, technically they totaled your truck, correct?
They gave me the option to total it.
Okay. Versus getting it fixed?
Yeah, just the fact because I was still paying for this truck from a dealership.
Okay. And and you said you have full coverage, correct?
Yes, sir.
So if you have full coverage, wouldn't that mean that your insurance would cover the rest of these repairs outside of your deductible?
In my opinion, from my experience, that's just insurance being insurance.
Okay, but you have $1,000 deductible on your insurance policy?
Yes.
Did you pay that $1,000?
I think that's what that's what they took away from the check they gave already. That's minus deductible.
So basically, they totaled your truck out for $2,932.19 and subtracted your deductible from it. Is that what you're saying?
I think in a way, I think so. Yeah.
Okay, so they did.
Well, you think so. That's what they did, isn't it? They gave you the option to total it,
Yeah.
which means they would take the truck and pay you money,
Yeah.
but they didn't do that.
Yeah. Because in my opinion, my truck's worth more than what they was going to
I
drive.
understand what your opinion might be, but I'm just trying to get a clarification on what your insurance company did. Insurance company did is they gave you the option. They paid what they would pay, which was basically $2,900. Took your deductible of $1,000. You got to keep the truck and whatever that was worth, and they gave you money.
I think so. Yeah. Yep.
Okay, go ahead, Mr.
Thank you, Your Honor. And sir, I want to make sure this accident happened on June 13th, 2025, correct?
Yes, sir.
Okay. And did you get any estimates before you reached out to your insurance?
No.
So how do you know how they came up with the number of what your truck was worth then?
Honestly, I don't know how they came up with that number.
Okay. And you were showing a couple exhibits here. One was a document you provided from Progressive, correct?
Yes.
And that document is dated June 25th, 2025.
So are we looking at people?
The Progressive document.
Oh, yes.
Yes. June 25th. Yep.
Okay. And so this accident occurred on June 13th, 2025, correct? So 10 days later, you had essentially resolved this issue with your insurance, correct? And how many vehicles do you own that you drive?
Just the one, sir.
Just the one truck? And with a broken cross member, is a vehicle drivable?
It's not safe to drive the broken cross member.
Okay. Yet you waited, and it looks like, and I don't have the exact exhibit number, but the date of the estimate for the cross member, that's dated July 12th, correct?
Yes.
So you waited after the insurance paid you out, you waited an additional 2 to 3 weeks to have your vehicle checked out.
The vehicle was closed.
Okay, so you didn't drive for 2 or 3 weeks?
Not with the cross member.
Okay. But again, it sat there after you received the insurance check, correct?
Yes, sir.
Okay. And then even later, and I just want to find the date here, I believe it is July 17th, that's when you got the quote for the body repair. Correct?
July 17th.
I don't know the number, that might be the 4,900.
That's people's two.
Do you see that date on that, sir?
On the 49 page?
Yes, sir.
Oh, yeah. Okay.
Okay. So July 17th is when you got that estimate, correct? Nearly a month after the accident and after insurance had paid you out on this, correct?
Yes, sir.
And you're saying you did not drive that truck that entire time?
No.
Okay. Why did you wait so long?
Oh, I mean, it was a job, and we saved, we tried to get a house, and it's not going on, and we just had to manage what was the insurance was going to cover, and,
And again, insurance had basically said this truck is not worth any more than the 2,900, right?
They did not say that. They did not say it was not worth that. They give the option. They shared. They know when they struck.
And your insurance, similar to a medical provider, correct? They have repair shops that they choose to work with,
My insurance did, yes.
and you chose not to work with any of the shops that your insurance works with, correct?
Yes, correct. Based on these receipts, these numbers on these receipts would have been a lot more than, it is if I would have went through the insurance.
But if you, so you have full coverage, and if you would have chosen not to total your truck, your insurance would have covered the entire thing, correct?
But if that's one of the truck, I would have gotten it, but I put it in the truck.
But you did total the truck, that's why they sent you the check. That's why you didn't have to pay your deductible.
They gave me the truck to fix the damages based on what,
But you never paid that $1,000 deductible, did you?
They added that deductible to the 1,900.
Right, so they subtracted it from essentially 2,900, so you never actually paid them, correct?
Insurance?
Correct.
I never paid insurance.
Right, so if your insurance would have covered the repairs, how that works, and correct me if I'm wrong, but you pay that $1,000 if they cover the rest, that's the point of full coverage, correct?
For the $1,000 deductible, right?
Yes, you would pay the $1,000 of either to your insurance or to the repair shop as your portion of deductible. The insurance company would pay the repair shop the rest, correct?
Yeah, so with the 1,900 they gave, yeah, like you were saying, that's with the 1,000 deductible. So it's like you said, it was like 29.
No, I think you're misunderstanding me, sir. If you had paid that deductible, your insurance company is Progressive, they would have paid A2 Auto Group or whichever auto group you had chosen to go through, correct?
They would have paid a little bit, they would have paid, the 19.
But you did choose to total your car.
No, yeah, I mean, I think it actually fallen in total.
Okay.
But I'm still, like I said, the truck's got a lot of life into it,
Oh, I understand that.
And for record, these trucks, based on facts, they go up to 500,000 miles. And my truck's only barely at 119. The truck's got a long life ahead of it.
Okay, and it's a 2007?
Yeah, but a lot of 2007 trucks are really nice. Inexpensive.
So what was your insurance company put a value on that vehicle, right?
The insurance.
They would have paid you a certain dollar amount, but taken the truck.
Well, like, I mean, I feel like it wasn't justified for the insurance.
I'm not asking what you feel. What your insurance company said is we would give you 2,900 for the truck. That's really what they said to you.
Instead of giving me the check, right?
Well, they would have given you 2,900 and taken the truck, right?
I believe so.
Okay. And so what they did, and they gave you the other option that they gave you was, okay, you're going to keep the truck. You need to pay your deductible. We'll give you the balance. And that's where the 1,900 some odd comes from, right? So at the time of the accident, your insurance company had valued that truck at $2,900, basically $3,000, $2,900.
To the insurance perspective, yes.
That's what they valued the truck. Okay. You don't have any further questions, do you?
No, you're all right.
Good. Any redirect?
No, Your Honor, thank you.
Thank you. You may step down.
Your Honor, people have no additional witnesses.
Any witnesses for the defense?
No, you're.
Okay, thanks.
Any argument?
Your Honor, I think the court's heard all the testimony. I believe the witness said he'd be asking for $3,000. I would ask the court order $3,000 restitution for the damage that the victim has shown through the receipts. Thank you.
Your Honor, I believe that damage should be capped at $1,000, which is the amount that this individual's out for the cost of his deductible. I find a lot of things in this case interesting, the fact that he did take the payout prior to even getting estimates to fix the work. He chose to not go through repair shops that would have been potentially fully covered by the insurance. That's the point of having insurance. I think, and I think there's almost a double dip at the apple here where he's received the insurance payout, and now is asking my client to cover the work that if his truck was worth it, his insurance would have covered. And so I think what he is realistically out based on the actions of my client is that $1,000 deductible that was deducted from $2,900, $32.19 amount when he was sent the check for $1932.90.
We're just gonna take a brief recess. I'll come back to a decision on it as well as sentencing.
Thank you, Dr. Paul Ross.
Yeah, what?
They said you can't.
In this courtroom moment, the judge carefully breaks down a dispute involving money, a truck, and a decision that changed the outcome of the case. The issue before the court is whether the defendant should be ordered to pay restitution. But after reviewing the facts, the judge explains why that may not be necessary. According to the testimony, the man involved paid $1,000 for the truck. Later, he received additional money, which the judge notes could have been used for anything, including repairs or other expenses related to the vehicle. From the court's perspective, there was no clear financial loss that justified ordering restitution. The judge points out something important. The man made a decision, and while it may seem unusual at first, the judge actually understands why he made it. If he had accepted the $3,000, the truck would have been taken back, and there was a real possibility he would never actually receive that money in the end. So the judge asks a powerful question in court. Why would someone choose that option?